Hello, this is Erick Widman from Passage Immigration Law. Thanks for joining us for our weekly live question and answer session. We've got a number of great questions as usual, and we're going to jump right into it. So, number one, if I have a long trip lasting about 8 months in the past 5 years, can I still naturalize? So the first thing to confirm is whether your required statutory period is 5 years or 3 years. So if you're naturalizing on the basis of being a permanent resident for 5 years and not 3 years because you're married to a US citizen, then you're correct that you want to look back over the past 5 years to confirm if you spent enough time in the United States. So if you are subject to that 5-year period and you had an 8-month trip outside the US, that could be problematic. If it's over a year, it's definitely a problem. But if it's over 6 months, that's in something of a gray area. And it may or may not have broken the continuous residence requirement. So you might not be able to fulfill the continuous residence requirement with a trip lasting between 6 months and 12 months. It's really similar to whether someone has abandoned their green card with a long trip. And CBP officer is trained to assess if you have abandoned your permanent residency with that long trip. They're going to assess your ties and connections to the US. So even though you took this 8-month trip, did you still have an apartment? Do you have a house in the US? Where were you employed, if at all? Did you have bank accounts? Did you have a current driver's license? Or did you effectively break a lot of your ties, if not all your ties to the US during that time? That's the type of assessment they're going to look into about continuous residence and whether you've fulfilled that requirement or not. So what you might want to do to remove that potential for a problem for your case is wait until that long trip is outside the 5-year statutory period. Good question. On to question number 2. I just had my citizenship interview, and it's been several months without an oath ceremony, without it being scheduled. Can an attorney help me with this? So for potential clients who contact us after they've gone through the process on their own, we think in some cases, in some situations, an attorney like us could help you out. Ideally, we would have handled the case from the beginning so that we could avoid longer delays. But with USCIS backlogs, with a big surge to try to naturalize people before the midterm elections this fall, there have in general been more delays with an oath ceremony. But yes, you could hire a good immigration lawyer to follow up on your behalf. You would get your attorney to file Form G28 with USCIS and then submit an inquiry, whether it's an e-request or contacting the local field office directly. Sometimes we call USCIS. Sometimes we get a senator or congressional rep involved. Sometimes we work with an ombudsman or our liaison with the American Immigration Lawyers Association, AILA, to help follow up on these delayed cases. So those are the various tools and the levers that an immigration lawyer has available. The most effective option is the potential for a lawsuit in federal court. And there's a statutory deadline, 120 days. It's a long time, 4 months effectively after your naturalization interview, that USCIS absolutely needs to give its verdict, give you a decision on your naturalization application. And you should be approved if there's obviously no reason why you're not eligible and you have no issues with the good moral character requirement. So there's a number of things, of course, you have to qualify for. But if those issues don't exist, you should get approved. That's the law. And they need to give you the decision on your application interview decision on that whole process within 120 days. That's the absolute deadline. Otherwise, federal court is where you could go next to get resolution. Next question. I have a B1, B2 visa, and it was 10 years. Oh, that you had a 10-year B1, B2 visa. But your problem is next year, this visit visa will expire. In 2018, my sister filed an immigrant visa for me. In this situation, can I renew my visitor visa? I've heard that after filing for a green card, it's not possible to renew a visitor visa. Is this true? Yes, indeed. We agree that it can be problematic. We've had clients and others definitely have issues renewing a visitor visa after a family member files for an immigrant visa petition. And the reason it's problematic is because to get a visitor visa, you have to show non-immigrant intent. You have to prove that you are going to return home after visiting the United States on your visitor visa. And there's a presumption that you don't have non-immigrant intent, that you do intend to immigrate. And that presumption is supported and it's enhanced when you have a family member who's actually filed an I-130 petition for you so that you can get an immigrant visa in the future. But the government, USCIS, other agencies have addressed the fact that when you have a sibling, which takes the longest out of all the preference categories, a really long time, 15, 20 years quite often, to finally get your priority date current and be enabled to come into the United States on the immigrant visa, should that keep a sibling from visiting the US for the long haul for those 20 years? That is also not fair. So the best way to handle it is to understand that CBP at the border is going to be looking for evidence of immigrant intent. The fact that your sibling has filed a petition for you won't automatically prevent you from coming in. And in terms of getting the visa renewed, you should be able to get your visitor visa renewed, especially if you acknowledge to the consular officer that you are going to maintain your ties and connections to the US, to your home country, and that when you visit the US, you're not going to suddenly overstay your visa. And in the past, on your prior visits to the US, you have not overstayed. So you should point that out as well. So it's not an automatic refusal or denial, simply having this pending visa petition filed for you. But you should be prepared to discuss the reasons why you are going to return to your home country and finish the process properly at the consulate when your interview date's finally called for your immigrant visa. All right. Now, what's the best thing to do? This is the next question. What's the best thing to do after you change your status and it's not showing to the US Embassy in your home country of your new current status? For example, you were admitted on a J1 and you changed it to an H1B. When your dependents apply for an H4, it's not showing your current status. Aha. Okay, so the US Embassy, as I understand it, is not properly understanding that you have moved from a J1 to an H1B, and therefore you have family members who could potentially get an H4. The best way to communicate that is by proof of that changed status, which is on either an I-94 document or an I-797C document issued to you, your receipt notice. If you change your status in the United States, you'll have a new official notice from USCIS. Then you'll provide that to the National Visa Center, the NVC, and they can provide it to the embassy. Or if you're in direct communication with the embassy, some of them provide email addresses. You can email the documents showing your official change of status according to the USCIS, and then they can use that to properly process the visa and issue the visa for your family member. Okay, everybody, thank you so much for getting in touch. It's been a pleasure. Let us know if you have any questions about these questions I answered, and feel free to get in touch for next week. Take care.